already expired, my lord. Inform me.
Close the matter. Take down. Heard Mr.
SM Borua.
SM Borua, learned counsel, appearing on behalf of the petitioner. Also heard Mr. S. Bora, learned standing counsel, GMD, appearing on behalf of
GMC and GMD.
GMC oblique GMD, appearing on behalf of the official respondents. Numbers 2 to 6, Mr. J. Hendik, learned Government Advocate Assam, is present on behalf of respondent numbers 7, 8, and 9. None has appeared for the remaining respondents. Stop. By filing the instant writ petition registered as a public interest litigation, bracket PIL, the petitioner had called into question the permission granted by the GMD authorities for construction of a multi-storied building by the respondent number 10, entirely on the ground that the building having been constructed on the slope of a hill and there being inadequate approach road, the construction is posing a safety hazard for the public of the locality. Full stop. Initially, there was an interim order passed by this court on (16/5/2007) restraining the respondent number 10 oblique respondent number 10 from proceeding any further with the construction work. However, the respondent number 10 as appellant had preferred civil appeal number 6118 of 2010 before the Honorable Supreme Court of India, assailing the said order. Full stop. The Honorable Apex Court had set aside the interim order dated 16/5/2007 by order dated 30/7/2010, passed in civil appeal number 6118 of 2010. Full stop. Thereafter, there has been no order of restraint by any court interfering with the construction work. Full stop. Today, when the matter is called up, Mr. Borua, learned counsel for the petitioner, submits that the construction of the building has been completed long back and his clients are also not in contact with him. Full stop. Mr. Borua has also fairly submitted that no live issue survives in this proceeding at this point of time. Similar is the stand of Mr. J. Hendik, learned Additional Senior Government Advocate Assam, and Mr. S. Bora, learned Standing Counsel GMC oblique GMDA. Full stop. After going through the record, we are also of the opinion that no live issues survives for consideration by this court in the instant proceeding at this distant point of time. Therefore, this PIL stands closed as infructuous. That's all? Yes.
In view of the above discussions, we find no merit in this appeal and the same is accordingly dismissed.
Yeah, I agree.
Obliged.
We'll find at least this part of the thing is too much.
You move it, but perhaps this kind of prayer will not be maintainable.
No, dear Lordship, just hear us tomorrow, then. Obliged.
Oh, similar prayer, yes, because this matter, there is a order against the order passed by the Register of Cooperative Society, whereby my registration has been cancelled, my lord. The order has been passed on 20th of this month, and we received yesterday only, my lord. And they insisted for liquidation. That is why there is urgency. Can it be tomorrow?
Tomorrow will not be possible. This court is rising early. You take it for third.
No, there's an urgency. Otherwise, I would not be approached.
What is
to
the
locate,
urgency?
my lord. They are insisting for liquidation.
Hmm.
No, that is why, my lord, yesterday we received it.
Saturday, Sunday, Monday being holiday, they will liquidate your
No,
company.
that they have given such an impression, mal. That is why I approached for losses, mal.
All right.
Tomorrow, mal.
All right.
Highly obliged, mal.
Item number 6, my lord, your lordship may not like to take up the matter, my lord.
Item 6, leaves this case before any other bench without me. I get my name. Why did you say so?
Your lordship appeared for one of the respondents, my lord.
Respondent number 4.
4, my lord.
Lordship, I beg to mention listing WPC 5277/23, Lordship. Urgent Lordship, dispute between the Moholdar or shopkeeper, Lordship. So Lordship, matter may be fixed.
After puja vacation, put a date. Yes,
Lordship,
next matter. After puja vacation.
Lordship, dispute is arises shopkeeper and Moholdar, Lordship. Please Tuesday, Lordship.
Disputed Moholdar.
Moholdar and shopkeeper, Lordship, daily market, Dolgaon daily market.
Hmm.
The shopkeeper and Moholdar also disputed arises, Lordship. So,
When was the writ petition filed?
7/9/23, Lordship, 2023.
It is to be listed for motion.
Yes, Lordship, 15/9/2023. And matter
And
may
say list for motion. 3rd October.
Yes, Lordship.
May I please, the lordship. I beg to mention for listing, lordship, on next week, lordship.
What listing, what matter, why it should be listed?
Lordship, the petitioner has submitted an application before the Registrar Kazi, and they are not registering
You
the,
want listing for final hearing
no admission, lordship,
after puja vacation.
obviously.
Yes.
Daily list for motion item 1.
May it please your lordship. Lordship, matter is filed as being aggrieved by the action of the respondents evicting from their land forcefully on 7/5/2023. And on the very next day, that is on 8/5/2023, they issued a tender notice for Pultoli weekly market over that particular plot of land. And that land is an annual patta land, your lordship.
Hmm.
So grievance is that if they had to leave that, then proper procedure should be followed. But here,
But
nothing.
now they have already done it.
But your
Annual
lordship,
patta land, there is no right to continue. There is no right over the land. It is only a user right subject to payment of fine.
notice should be given to them. They have been harmed from
All
that.
right, we'll
and-
examine it. Hard Miss K. Jain, learned counsel for the writ petitioner, peruse the amendments made in the writ petition. And 6 weeks since Miss,
Lord, even if the fact that they have paid the revenue or not, they have not.
we'll examine it. That's all.
Lordship, interim prayer may kindly be considered
Interim what?
regarding that Pultoli weekly market should not be continued over that plot of land, lordship.
Miss M. Burma, London Government Advocate Assam has appeared and accepted notice for respond numbers 1 and 2, whereas Mr. P.
P. Handick, my lord,
P.
3, 5,
Handick.
and 6.
Learned. You are for
1.
the 1, 2, and 4, whereas Mr. P. Hendik, Learned FC,
Just
Yeah,
3,
no,
my lord. On a number.
Assam has appeared and accepted notice for respond number 3. As such, no formal notice is required to be sent to the respond numbers 1 to 4. Extra copies of the writ petition, requisite in numbers, be furnished to the learned standing council. Petitioners to take steps for service of notice upon respond number 5 and 6 by registered post with AD. Hard on the prayer of interim relief. This said prayer will be considered after service of notice upon all the respondents. It is, however, made clear that any order of market settlement made during the pendency of the writ petition will be subject to final order that may be passed in this petition.
Deeply approved.
Supplementary list for motion item 10.
May I please, your lordship? Lordship, I have received instruction, your lordship. The impugn note order has been withdrawn, your lordship. The letter has been withdrawn. And both the parties are called for hearing today, your lordship.
Heard Mr. S. Banik, learned counsel for the writ petitioner, also heard Mr. V. Rajkua,
V. Rajkua, your lordship.
learned standing counsel, Corporation Department, Assam,
1 to 4, your lordship.
appearing for the respondent numbers 1 to 4, and Mr. A.B.T. Hawk, learned counsel, appearing for respondent number 6. Ms. M. Burman, learned G. Assam, is present on behalf of respondent number 5. Today, when this matter is called up, Mr. Rajkua submits that the impugn order has been withdrawn by the authorities, and both the contesting parties have been called for hearing today in the matter.
I'm told today, your lordship. in a-
Full stop. If that be so, this writ petition has been rendered infructuous. Mr. Banik, learned counsel for the petitioner, has also fairly agreed to the said proposition. In view of the above, this writ petition stands closed, the same having been rendered infructuous.
Lordship, may I? Lordship, my name is shown as B. Rajkua, your lordship.
No, we have
It's
corrected it.
V. Rajkua, your
There are problems everywhere, you understand.
lordship. Lordship.
V is always heard as B.
No.
So what to do?
Much obliged.
David is for admission item 2 and 3.
People peruse the last order. They were, the finance department was directed to bring instructions. In 1890. Ayakundi. So Nayak was here short time. He's got the instructions. I've spoken to him.
So
I see.
Mr. Nayak is not available, is it?
He was here. What he has conveyed to me, if I may submit that the finances, no objection, it's the judicial department will do the calculation. And what we are calling upon the judicial department is to just implement their own notification dated 16/8/2016. And that is what the High Court is also saying. If your
Where is
lordship,
that notification?
at page 28 of our IA. Page 28. The second principal seat pay shall be admissible to the officers and staff of the principal seat of Guwahati High Court in addition to the respective pay in the payment and grade for determining basic pay. That is, basic pay equals to pay in payment plus grade pay plus PSP.
Now, this pay in the pay band plus grade pay plus PFP
Yes,
is also applicable to your clients.
yes, Lordship.
But your grievance is that there is a computational error.
No, our grievance is that while calculating, calculating our revised pay, what they did was they calculated the increment while taking into account just pay in payment plus grade pay. They did not add the PSP. After calculating the increment, they added the PSP. That is the error which they did.
So according to you, while calculating the increment,
The basic
PSP
pay,
is also to be added.
yes, yes. That is what these notifications is. Because the basic pay comprises of these three ingredients. That's what.
And what they have done is their basic pay has been computed on the basis of pay band plus gate pay.
Yes,
And
excluding the
thereafter,
PSP.
PSP has
Yes,
been added to that.
yes, thereafter. They have calculated the increment on that sum total of the grade pay in payment plus grade pay, excluding the PSP,
So
which
that has been done only in case of computer assistance or all?
only in
all
respect
employees?
of these. That is why the administrative side of the High Court had objected to that calculation, because this is in violation of these notification. If you're
Where is that objection by the High Court?
yes, at page 25, 23/12, 2022. Page 25. The last three paragraphs, if your lordship peruses the last three paragraphs. যিখন আমি দিছিলো হাইকোর্টে I idea.
Yes, so what has happened after this?
After this, there is that is why we had filed this. There was no communication from the other side, from the finance department. That is why on the last occasion, the finance department was directed to bring the instructions on what they have done with this. But
May pleases your lordship. P Nayak is on legs, your lordship. Kindly pass over the matter for time being, your lordship.
Legs where? He's on legs in which court?
Court 1.
I'll take it up after 15 minutes and then pass the order. Beyond that, it will not be possible.
Instruction to keep the evidence. I can go.
Madam, the next matter I'll submit when Mr. Nayak comes. Item 3. Similar matters, but they have not taken decision in case of our petitioners. There is a senior personal assistant of the registry.
All right.
They are similarly situated.
Here, my lord, the sole issue, my lord, here in the petition, my lord, since the pendency of the civil suit, my lord, the notice was issued, my lord, by the Tinsukia Municipal Board. And to that effect, my lord, since in other issues, whatever the other merit of the case, my lord, let the civil court decide, but only on the point of this notice, my lord, since this division bench of this honorable court has said that there is a decision of this court, the pendency of this civil suit, and any case, my lord, the notice should not be issued. This is in parallel proceeding on the same issue, only to that point, my lord. If lordship will go on the merit of the case, my lord, then I have to file a reply, my lord, since they have. If the matter had to be decided by civil court itself, only on the issue of the that particular notice, my lord. Here division bench in para 15, lordship, I'm just trying. And whatever the affidavit has been filed, my lord, that point, my lord, already they have filed their written statement before the court below, my lord.
Yes, who is appearing for the,
Lord,
the complainant is not a party. here,
Not a
is it?
party here. We have
And-
changed the mentally.
In the complaint and also, my lord, they have filed one caveat, my lord. They say that they did not file their complaint. In the caveat, they said.
No, we can't go into these things. If the complainant is
uh,
not a party.
No, only, my lord, the complainant, my lord, we do not have to say anything against them, my lord.
Oh,
Only,
you can't tell me what I have to say or I
Lord,
don't
I'm
have to
sorry,
say.
my lord.
We'll go by,
Only I'm concerned with the notice, my lord. Notice is parallelly, my lord, since this division bench and single bench said that's when the matter is pending for the same subject matter, this notice. should
Mr.
not be issued.
Chetri, I think on the last occasion also, this issue was confronted.
That too, my lord. Otherwise,
The order I'm going to pass here is direct you to go back to the authorities, file a review, and they will have to decide it after hearing the version of the writ petitioner and the complainant. If you would have implicated the complainant as a party, we would have set aside the notice and protected your interest. You won't do it. We will not pass an illegal order. That's the problem. What to do? That's the law. We'll go by the law. When you have a dispute, the ground you're urging is a law point. But that doesn't mean the other party should not be implicated as a party. You come before the court being aggrieved by a notice issued at the instance of the other side. You don't make him a party. And you want a final order in this case that the notice should be set aside. How is this possible, Mr. Chetri? This issue was clearly pointed out on the last day. It was pointed out to you that that kind of order will not be permissible. You want a particular kind of order which suits you, that you are entitled to ask for. But as the court of law, we'll have to pass orders which are in accordance with law. So tell me what to do.
after 10 days,
Huh?
after 10 days,
After 10 days, what will you do?
regarding development.
No, but may I ask you why the complainant has not been implemented? Is it a mistake or is it a deliberate? You may have done it deliberately and you may have justification
No,
for
only
that.
probably that time I thought that only since the notice was issued by the municipal board
Hmm.
and the municipal board on the basis of this division bench judgment and single bench judgment, I have gone through it. Then it was prepared that if it is so, then notice is bad in law. Since a parallel proceeding is
That-
pending.
That is your ground. That is the
That
ground
is
for
that is
challenge.
why, my lord, I did not make them party, my lord.
No, but are you saying if you have a good case, then the other side need not be implemented? Is that your argument?
That is why, my lord, now 10 days may be granted.
I could have disposed of this matter today. It will not be permissible. If you want a final order setting aside
That's
the
true,
notice,
my lord. My lord,
not possible.
so my
This
lord,
court, that is not possible. These are fundamental principles.
I will bring it, my lord.
He is appearing for whom? You are appearing-
I'm for the municipal board lordship 2 and 3 lordship.
What is your stand?
Lordship.
What about the stand of the board on his argument? We may not be able to, see, he had a good case.
Lordship,
Only thing is if you would have implemented the complainant,
lordship.
that was the end of the matter for the board.
Lordship.
He didn't do it. That means you are getting some breathing space.
Lordship.
But what is the response to the fundamental argument?
Lordship,
Today or tomorrow, that issue will
we
be
have,
considered.
we have given them a chance to reply to that. Prior to that notice, we have noticed him to reply to that. He doesn't follow that notice, Lordship. That's why this impugn order has been passed, Lordship.
So, Mr. Chatri, why don't I dispose of this matter by giving them 10 days time to decide on your objection? That will expedite things. Otherwise, you will implead now, then impleadment is not enough, notice has to go. It will delay the matter further. What do you say?
As your lordship please. As your lordship please.
No, you make your submission. It is always what the court pleases.
Yes, yes.
There is nothing, nobody else will be pleased to pass an order. But I am asking for what is the stand of your client? That's what I am asking.
Well, my stand, whatever I have submitted before lordships, that since the notice in earlier occasion also they issued notice, my lord, we have given the reply.
Hmm.
We have given the reply. my lord.
You have already submitted
Yes.
reply to this notice, 9/8/2023.
Earlier occasion, another notice was issued prior to that, my lord.
Hmm.
Then we have given the reply,
That notice was saying what?
saying nothing, my lord.
Saying you have
They say nothing. Only I have stated, my lord, that
If
as
they
per-
said nothing, then what have you
No,
replied?
no, they said nothing. Only my contention was that we have complied with the provisions of the construction, whatever it was said by the municipal board. And my lord, in the civil suit, my lord, even the municipal board has filed written objection as well written statement in my favor, saying that since in the same vicinity, alternative parking space has been given by the petitioner himself, my lord.
Hmm.
Whatever the parking is required, since in the proposed building, my lord, some persons, the shopkeepers are there, and against them, this civil suit has been filed for vacating, my lord. And the matter is pending. So till then, the alternative parking has been given to the municipal board, and municipal board accepted. Now, as because I have filed this petition again against the municipal board, now they are saying some reverse. But whereas they have already accepted my view. My contention has been accepted by filing the written statement.
Lordship, our case is that he has violated the building permission, Lordship.
They have said nothing has been violated in the WS.
Let us see, where has it been said in the notice?
Lordship, Lordship will find
Hmm.
the written objection filed by the
No, let us first see the notice. What is the ground?
first notice they have issued, my lord, lordship will find. Lordship will find page 45, lordship, first notice. (13/7, 2023). Lordship got it.
1 minute.
Then second is my reply, my lord.
So this is a final notice of stop construction.
No, Lordship, that thereafter we made an inspection, Lordship. Thereafter this 9/8/2023 notice was
So 9/8/2023 is the final
final
notice.
notice, Lordship.
So it is stop construction forever. Where does it say that it
is
there is a
until-
violation, deviation of the construction plan? Where is it mentioned in this order?
Deviation.
That we filed in the affidavit.
No, if not notice, it is not.
In the notice, it was that you, in the notice, we have stated that our concerned staff have today physically verified the proposed
No,
alternate.
that's
parking-
correct. I am asking you,
Lordship,
this is the final notice, final order, is it not?
Hmm.
9/8/2023.
Lordship.
Where has it been mentioned that there is a violation of the construction plan, approved plan? Where is the statement?
Here it was not there, but in the affidavit we have stated, Lord.
You are lucky. If had he implemented the complainant, it was over. Heard Mr. B. Chetri, learned counsel appearing for the petitioner. Also heard Mr. S. S. Roy, learned counsel representing the respondent numbers
2, 3 and 4.
2, 3 and 4. Ms. M. Burman, learned G. Assam is present on behalf of the respondent number 1. On the request of Mr. Chetri, this matter stands adjourned for 2 weeks so as to enable him to file an interlocutory application seeking implement of the complainant as private respondent. Registry to list this matter after the IA has been filed by the writ petitioner.
Lordship, in this matter, Lordship, I have taken instruction, so far as 2 is concerned, Lordship, I have taken instruction from the department.
So far as 2 means item,
Yes, it's WPC number 4464, Lordship.
yes, yes.
Yes, Lordship, they have stated that so far as error in calculation of basic pay is concerned, it will be done by the judicial department, Lordship. In case of any clarification, they may approach the finance department. So Lordship may dispose of this matter in directing the judicial department to take a call on this issue.
So in item 2 or WPC 4464, these are all computer assistants.
Yes, Lordship.
And they are entitled to the benefits under the 2016.
ROP 2007.
That is 16/8/2026.
Yes, Lordship.
So let me pass an order in this first,
Lordship.
then we'll deal with the other matters.
Lordship.
Lordship, just one more document, it will make the order more. If your Lordship takes up page 30, the fact that the ROP 2017 has been made applicable to the employees of the principal seat of the High Court, that order is there. That if you
Page 30 of?
page 30 of the I. This is a letter from the Judicial Department to the Registrar General, Guwahati High Court. Proposal.
In notification concern.
That notification is also referred to, and this has been issued in concurrence with the Finance PRU Department, this letter.
Lordship,
So-
in my humble submission, Lordship, the issue is limited only to the extent of calculation of
Yes,
basic
yes,
pay.
yes.
Other
yes.
is
Who is appearing for the Judicial Department?
comment.
What do you have to say? Sorry,
File is not available.
file is not available. That is a problem.
So when the finance says the Judicial Department will take a call,
No,
and
all
it's
right, we'll
the,
dispose it.
it's their own notification.
Take down. Miss, it was WPC number 4464 of 2022. তার লগতে IAC P13 of 2023. Heard Miss D. Borgohai, learned counsel appearing for the writ petitioners. I have also heard Miss M. Burman, learned government advocate Assam appearing for the respondent number 1. Mr. P. Nayak, learned SC Finance appearing for the respondent number 2, and Mr. N.K. Sharma, learned counsel appearing for respondent numbers 3 and 4. First of all, the core controversy involved in this writ petition pertains to an allegation of computation error made by the writ petitioners while giving effect to the revised pay scale applicable to the employees of the Guwahati High Court principal seat as per the revision of pay bracket ROP rules of 2017.
Lordship.
The facts of the case lie in a narrow campus and can be noticed as follows. Stop. The read petitioners herein are working as computer assistants posted in the principal seat of the Guwahati High Court. As per the service rules, the petitioners are all employees of the principal seat of the Guwahati High Court. Full stop. By the notification dated 16/8/2016, the government had approved the proposal for payment of principal seat pay bracket PSP bracket close to the officers and staff of the Guwahati High Court bracket principal seat with effect from the date of the notification.
Date of
Is it?
notification.
Stop. Be it mentioned herein that the notification dated 16/8/2016 was issued with the approval of the cabinet. Full stop. The aforesaid notification clearly mentioned that the principal seat pay shall be admissible to the officers and staff of the principal seat of the Guwahati High Court in addition to their respective pay in the pay band and grade pay, meaning thereby that the basic pay of the employees is to be treated as pay in the pay band plus symbol plus grade pay plus PSP. Full stop. Accordingly, the officers and staff of the principal seat of this High Court was extended the benefit of the revised pay scale as per the aforementioned formula. However, when it came to the case of the computer assistants, the department had computed the department had calculated.
Lordship, may I just interrupt for a minute? Lordship, in this case, these were the computer assistants who were appointed prior to the coming to after the coming into effect of the rules and prior to the publication of the rules. That was the period that was why the whole confusion arose.
Prior to the
Publication of the rules and after the coming into effect of the rules.
Lordship, may, Lordship.
We'll hear the matter in December.
Yes. No,
There are a lot of
in-
things.
No,
initially,
nothing, Lordship, because
Choose a date in December, we'll hear the matters finally.
Lordship, initially issue was different.
Mm.
This is an offshoot of the main petition, Lordship. The main issue was at page 103 of my affidavit, Lordship.
Yes,
It was relating to use of option, Lordship. It was delayed. Accordingly, Finance Department come down. The matter got concluded there, Lordship. Subsequently, when the pay was calculated, this error.
Choose a date in December.
no, Lordship, they've condoned the basic
Okay.
issue they've
The
taken care of.
condemnation was the main issue.
The calculation, so that even now they've
Was computed only on the basis of the pay in the pay band plus grade pay by excluding the PSP. Full stop. The apparent reason for doing so is on account of the fact that the read petitioners herein were all appointed prior to the notification of the ROP rules of 2017. But after the notification dated 16/8/2016 was issued by the government of Assam, approving payment of principal seat pay. Full stop. It will be pertinent to mention here in that in the read petition, the grievance expressed by the petitioners was on account of the fact that was primarily on account of the fact that that is the grievance.
Yes.
Same grievance only. Prayer number 2 says calculation error. Prayer number 1 says fix the salary of the petitioner. In the writ petition filed by the petitioners, one of the basic relief sought for was for issuance of a direction to fix the salary of the petitioners under the revised pay rules with effect from 1/7/2017. The petitioners had also sought for a direction to approve the calculate, before that, if I write, in the original writ petition, লিখেছি, তার আগতে লিখো। Taking note of the grievance expressed by the petitioners pertaining to erroneous fixation of pay scale, the joint register bracket finance bracket close of the Guwahati High Court had addressed a communication dated 23/12/2022, pointing out that the pre-revised fixation of pay of the computer assistants ought to be rupees 8,750 rupees sign. And after 3% increment, it would become 9,020 with effect from 01/07/2017. As such, the revised fixation of pay with effect from 01/07/2017 with regard to the ROP Rule 2017 would be 24,160 bracket next higher stage of table number 1.7 bracket close. It was accordingly mentioned that pay in respect of all other officers and staff of the registry had been fixed after adding the PSP with basic, that is basic equal to pay plus grade pay plus PSP as admissible in the government notification dated 16/8/2016. Accordingly, a request was made to the Judicial Department of the Government of Assam to rectify the computational error. However, notwithstanding the aforesaid communication, no action had been taken by the Judicial Department in primarily taking the plea that the approval of the Finance Department is required in this regard. It will be relevant to point out herein that the writ petition so in the writ petition also incorrect fixation of pay, that is what is the grievance. Why do you say it was something else?
Lordship, just one paragraph, Lordship. Lordship, I kindly see 102, Lord, of my affidavit. I'm not the use of.
You are trying to say that writ petition is something else by showing your affidavit.
No, yes, Lordship. In the writ
I will
petition,
not.
they were,
Please take a sip. These are wastage of time.
no, that issue has already been resolved. There's no use of discussing that issue.
It appears that some other issues raised in the writ petition have already been resolved, but the only contentious issue that remains to be resolved at this point of time is to refix the basic pay of the petitioners after taking into account the the pay in the pay band plus grade pay plus PSP. First up. On 18, taking note of the facts and circumstances of the case, on 18/5/2023, this court had passed. Not 18/5, sorry. On 18/9/2023, this court had passed an order directing the Learned Standing Council Finance Department, Assam, to obtain necessary instruction as to the claim made in the writ petition. First up. Today, when the matter is called up, Mr. Nayak, Learned SC Finance Department, has disarmingly submitted that the the Finance Department would have no objection if the necessary computational error is rectified by the judicial. That's not the point.
So far as calculate error in.
This is better before any other.
Lordship, one line only, Lordship. Lordship, one line, just one line, Lordship.
Yes, go to some other bench.
Lordship, so far as error.
Every day things are changing.
One
every
line,
day.
I'm not changing, Lordship, just one line. So far as error in calculation is concerned, that will be dealt with by the judicial department.
That's what I was dictating. Why did you interfere?
Lordship, use the word no objection, Lordship.
You have an objection if the judicial department,
No, if any clarification is sought for, finance department definitely give them, nothing else, Lordship.
take down. This is absolutely unacceptable.
I'm sorry.
This is what I was dictating. What have you written? Computational error is rectified by the judicial department, and in this regard, if any clarification is required, the finance department is ready and willing to provide the same. First up, if that be so, the grievance of the petitioner expressed in this proceeding apparently stands resolved. Ms. Borgohai, Learned Counsel for the writ petitioner stroke applicants, has also fairly admitted to the said position. First up, Ms. M. Burman, Learned GA Assam, and Mr. N.K. Sharma, Learned Standing Council GHC, appearing for the respondent number 1 and 3 and 4 respectively, have also submitted that since it is only a question of computational error, they would have no objection if the writ petition is disposed of with a direction upon the judicial department of the government of Assam to carry out the necessary rectification in the computational error and issue appropriate notification. First up, taking note of the submissions made at the bar, this writ petition as well as the interlocutory application is hereby disposed of by directing who is the authority will do it?
Lordship, judicial department.
What is the respondent number?
1.
Directing the respondent number 1 to take note of the communication dated
One, no?
take note of the projections made in the communication dated 23/12/2022 issued by the Joint Register Bracket Finance, Guwahati High Court, a number to Didigo. Communication number, letter number HC.Roman 8-154/2017/3067/SE issued by so and so. And after carrying out the necessary correction in the computation and fixation of revised pay scale in case of the writ petitioners, fresh notification be issued. In doing so, if any clarification is required, the same may be sought from the finance department. That's all you want?
Yes, Lord.
Anything else?
No.
All right.
Lordship, we want something more.
With the above
Lordship, the
observation,
arrears salary will be released, Lordship, within a fixed time period after.
needless to say,
rectified.
the exercise as directed by this court shall be carried out and completed within a period of 60 days from today, and the petitioners shall also be extended the benefit of arrear salary
Yes.
and allowance,
We do.
which may be admissible under the rules upon such fresh computation within a further period of 60 days from the date of issuance of the notification. With the above observation, the writ petition as well as IS stands disposed of. What more you want?
That is what I wanted, Lordship.
Okay. What is the next matter, please? Let's come to the point
Lordship,
quickly.
it's a similar matter, Lordship.
Hmm.
In the earlier case, condonation was granted by the finance department. But in this case, Lordship, yesterday I have given one copy to my clerk for filing affidavit, Lordship. That is not yet filed, it will be filed today. Here, we have simply taken the step that no such proposal has yet been received by the finance department from the judicial department.
My lord, if I can.
We
take-
have not yet gone to the merit of that.
If I can take your lordship to one page of this writ petition, my lord, where there is a communication
So,
from. this-
Mr. Nayak, you want to file an affidavit?
My affidavit will be filed today, Lordship, but most importantly, judicial department instruction will be necessary, Lordship. What happened to that proposal?
They are also employees of the
High Court.
High Court.
There,
There is
We
senior
have
personnel.
officers?
yes.
One by one, please. I'll hear everyone. Please don't confuse.
In that case, Lordship, there's senior personal assistance, Lord, personal assistance.
Senior personal
Yes,
assistants.
Lord.
They were appointed when?
After coming, date of coming into effect of the seventh ROP, Lordship, but prior to issuance of notifications. Same issue, Lordship. Only part is condonation. In their case, it has been condoned, but in this case, Lordship, no such proposal has yet been received by the finance department. Once it is received,
Proposal for condonation.
yes.
Why it has not been sent? Has the High Court sent any such?
Yes, yes, since 2018, it is, I'm.
Where is the High Court proposal?
My lord, I want to mark.
Page 65 once. This was in 2021. Prior to that also.
Prior to that also High Court sent me. Page 65 is the final. But judicial department, I believe, as my friend said, my lord, judicial department may not have forwarded this.
So then we close it by directing the judicial department to take necessary steps on this. That's all. That they will take necessary steps. We'll record your submission that no proposal for condonation has been received in case of the petitioners involved in this writ petition. As a result of which the finance has not expressed an opinion.
Yes.
So the judicial department will have to act on this, take necessary steps, and send the proposal to the finance department.
My only question will be, it is not necessary that in this case it has been condoned, so other case also it will be condoned. That is not answer me. They will consider.
We will consider it in accordance with the,
Well, we are similarly situated, so they cannot create a separate.
the
class.
same order cannot be passed here. You also know.
No, but
That's
my agony is only thing is that it will be just like it is since 2018 or 21, it has been kept lying there in the
What
judicial
is the order
department.
you want today?
Now, my order, my lord, my respectful, my lord, prayer before your lordship to keep this writ petition open and pass an interim order directing the judicial department to send it within a specified time and to act on this by the finance department within a specified.
That can be done. That's the final order. That's what I'm saying. I'll pass this order.
But my only prayer, my lord, let the writ petition be kept up.
Then only adjourn for filing affidavit, nothing else.
No, my lord, I appreciate, my lord. Otherwise, again, they will keep it
Lordship,
pending.
let my affidavit be filed today, Lordship. In the meantime, judicial
No,
department.
no, my affidavit, what has been said in the affidavit has been narrated by my friend.
I heard Mr. H. Amwa, learned counsel appearing for the writ petitioner. Also heard Mr. P. Nayak, learned SC Finance Department, Assam, appearing for the respondent number.
Finance one, Lordship.
It submits that affidavit on behalf of the department is ready and shall be brought in record during the course of this week. As such, Mr. Nayak seeks adjournment in the matter. Full stop. Mr. Chomua, on the other hand, has invited the attention of this court to the communication dated 24/3/2021. Bracket annexure 14 to the writ petition, bracket close, to submit that despite receipt of the aforesaid communication from the joint register bracket finance of the High Court. It is not known till today as to what action has been taken by the judicial department on such communication. One stop. Miss M. Bormon, learned government advocate Assam, appearing on behalf of the respondent number 2 submits that no instructions on that behalf is available with her till today. Full stop. Similarly, the stand of Mr. MP Sharma.
Lordship, I have received instruction, Lordship. I have received instruction that the case of the computer assistance and that of the petitioners herein were processed together, lordship earlier. But in respect of the computer assistance, the judicial department has given
So you
it-
file your affidavit. Mr. MP Sharma, Learned Counsel appearing for respondent numbers 3 and 4 submits that he has received instruction and will file affidavit within 2 weeks from today. In view of the above, this matter is directed to be listed again after 3 weeks. In the meantime, the respondent numbers 2 and as well as 3 and 4 shall also file their respective affidavits responding to the allegations made in the writ petition. It is made clear that if the affidavits are not brought on record within the time fixed by this court, this matter will be taken up for disposal on the basis of materials available on record. Let them file their affidavits.
Lordship will fix a date kindly. madam. At
It
least
can't
one,
be before vacation if you want a date. Instead, 3 weeks means take a chance, it may be listed.
if lordship fixes, then it will have been one prayer of today's statement.
On the request of Mr. Chomo, this matter is directed to be listed again on 7th of November 2023 as a fixed item.
Right. Well, the court is reopening on first. Not sure if it's 7th of November, little before that, right?
When do you want it?
Actually, I prayed for a date prior to the vacation. Well, these are all decided matters. Lordship has just now disposed it of. Nothing more to deal with this. Only for our formalities that the judicial, there is a lackings in the judicial department.
All right, list it on 19th of October. 19th of October or 18th of October. 18th October. What will happen is this will go to December now. That's why I didn't want to. You are not updated with the corrected holiday calendar of the High Court. You are still looking at the old one. Things have been changed.
All right, then, my lord, then it is. I'm sorry, my lord, I'm sorry.
You are looking at the calendar which is not valid. So
Sorry.
therefore, your anxieties are not valid, your submissions are not valid. 7th would be a date when we can finish it off.
Yes,
finish it off.
7.
One day before vacation, they will find a way to postpone it. And then it goes to December.
All right, 7th of November.
All right, 7th of November.
Supplementary list for admission item 11.
May I please?
Yes.
Letter pertaining to non-payment of outstanding dues amount, my lord.
Lordship, in this matter, the affidavit is ready. We have sent it for vetting. Sometime maybe granted, we'll file it, Lordship.
My lord, there's-
What is
it's a
the
court
affidavit?
case, my lord,
There's some law point involved here.
No, Lordship.
Then what is your instruction?
Lordship, we have made a payment of 6,27,830 out of his bill 8,99,900 9 rupees, 99,009 rupees, Lordship. Other payment, Lordship, in this matter, there is central share and a state share. Lordship, that we have not received the whole amount, Lordship. That is our stand, Lordship.
No, but how is the contractor bothered about it?
Lordship, we are making part payments, Lordship.
He wants full payment.
Yes, Lordship, but we are also,
Do you float tenders and allot work without the fund?
no, Lordship,
Then if the fund was there, where has it gone?
no, Lordship.
No, please, Mr. Sharma, please listen to the question. Does the government department float a tender without budgetary provision?
No, Lordship.
That means the budget was available when the tender was floated for this work, is it not?
Yes, Lordship.
Where has that money gone?
Lordship, there. I don't have instruction on that, Lordship, but
Then now you will have to file an affidavit indicating that. That is the affidavit you will have to file. You file it within 1 week. All right, heard Mr. So-and-so, learned counsel for the petitioner, also heard Mr. C. Sharma, learned counsel appearing for the respondent numbers
all the responsible.
1 to 4 who
Yes.
submit that affidavit on behalf of his clients is being prepared and shall be brought on record within a week from today. On such ground, a prayer has been made to post this matter again after 2 weeks. Prayer is allowed. However, in the affidavit to be filed by the department, it will also be projected as to whether the work in question was allotted to the contractor without necessary budgetary provision. And if so, has there been any diversion of fund in this case? Let them file the affidavit. Let this matter be listed again after 2 weeks.
For hearing item 5.
This has become infructuous for the election of 2013 Panchayat election.
Yes, Lordship.
Mr. Your name, please?
A. Alim Sheikh Lordship, on behalf of Mr. M. U. Mondal.
A. Ali,
A. Alim Sheikh.
A. Alim Sheikh, Learned Counsel appearing on behalf of Mr. M. U. Mondal submits that after the holding of fresh panchayat elections, this writ petition has become infructuous. Similar is the stand of Mr. H. Sharma, Learned Additional Senior Government Advocate Assam, and Mr. R. Dubey, Learned Counsel appearing for the
Assam State Election.
Assam State Election Commission. In view of the above, this writ petition stands disposed of as infructuous. What is this miscase about?
Miscase Lordship, it is also.
Yes. Yes,
All right.
please. Yes.
Item 7 and 8. Item 7 and 8.
Mr. Henrik, what is this matter?
Long matter, my lord, that old matter, this is the 1944, my lord, the settlement order was issued. In our affidavit, Lordship, may I kindly see the paragraph 4, Lordships. The land measuring, Lordships, 1,668 bigas, 3 katas, 13 letters.
I'm sorry, my lord, in this case, my lord, I'm no longer in this case, my lord.
What is there? There's nothing in this case.
Nothing, Lordship.
There's no live issue.
Well,
If, my lord, the advocate who engaged me, he has taken back the brief.
There is no stay order also.
no.
Last year.
We will dismiss it. It will be open for the petitioner to.
Yes, yes. I'm sorry, madam.
No, it's all right. Restrain them from evicting.
Lordships.
What is the other matter? Let us see, 2018.
Already evicted, like Lordship. 2018. Eviction order.
All right, take down. Both these writ petitions. None appears for the petitioners when the matters were called up. Mr. J. Hendig, Learned Additional Senior Government Advocate Assam is present on behalf of the official respondents.
Oh, 2 and
you-
3 lordships.
Official respondent numbers 2 and 3. Mr. A. Bhattacharya, Learned Council has appeared for respond numbers
1 and 4.
1 and 4. Full stop. In these writ petitions, the basic prayer of the petitioners is to restrain the authorities from evicting them from the land in question. Full stop. When the matters were called up, Mr. A.K. Purkast, the Learned Counsel for the writ petitioner, who was present at the bar, submits that he is no longer appearing in this case as the petitioner's counsel. No other counsel has appeared for the writ petitioners. Full stop. It further appears from the record that the petitioners were absent even on the previous occasion. Full stop. Having regard to the nature of relief prayed for in these writ petitions and the fact that no interim relief was granted to the petitioners, it is evident that the eviction drive has already been carried out and completed, and therefore no live issue survives in these writ petitions at this distant point of time. Considering that these are old matters and none has appeared for the writ petitioners to press the issues, this court is of the opinion that nothing further survives for adjudication of the adjudication in these writ petitions. The writ petitions are accordingly closed as infructuous.
Obligers.
If there is IA, then it has to be dealt with. Yes. What else?
May I please, your lordships, these matters relates to petitioner have challenged the impugn official communication dated so and so.
So and so.
Uh,
What is so and so? You tell me what so and so is.
communication HDB 14 of the RD
Sorry, sorry.
IAY. Communication number HD
Which page in the writ petition?
synopsis matter.
You don't know whether the communication is annexed or not. You are not aware.
Annexed, my lord.
Where is it annexed?
Page 15.
Page 15.
In the meantime, after obtaining interim order, petitioner has no communication with us. So
We'll close it as infructuous.
Beneficiary list. Beneficiary list. BPL. Lordship, main annexure E page 69, lordships. They are asked to मला submit a fresh BPL card order, my lord, that list of the my lord, the BPL
Page 69.
69. Earlier, they have been submitted where some of the my lord, the person whose names are not reflect, my lord, found in the my lord, that BPL list, lordships.
Letter dated 10/6/2000.
Lordship 11/12/2013, lordship.
No, this court has state the letter dated 10/6/2014. Where is that letter dated 10/6/2014?
page 91.
Is the IAY scheme still in vogue? Can you find out from the Google? Mr. Hendik?
Lordship. AY scheme is not there. PMY scheme is there now.
Lordship, earlier occasion, WPC was filed on 2014. There was a
Where is
direction,
the order?
page 84,
Page?
84.
Take down. Heard Mr.
SK Das.
S.K. Das, learned counsel appearing for the writ petitioner. Writ petitioners also heard Mr. J. Hendrik, learned additional senior government advocate Assam,
I am for respond number 4 and 5, Lordships.
appearing for the respondent numbers 4 and 5. None has appeared for the other respondents. Full stop. In this writ petition, the communication dated 10/6/2014 issued by the
Video.
Block Development
Development.
Officer, Hailakandi Development Block, that is the respondent number 6 herein, has been assailed internally on the ground that the said communication is not only illegal, but is also in contravention of the earlier order dated 25/5/2014 passed by this court in WPC number 2504/2014 instituted by the same petitioners.
My lord,
Earlier petition was same petitioners.
others petitioner also there.
Instituted by the petitioner, instituted by some similarly situated persons, including some of the present petitioners. Full stop. By taking note of the grievance expressed in the writ petition, the learned single judge had passed an interim order dated
14.
14/7/2014. Restraining the respondents from implementing the letter dated 10/6/2014 without complying with the earlier order dated 21/5/2014 passed by this court in WPC number 2504/2014. It appears that the controversy raised in this writ petition is pertaining to preparation of list of beneficiaries for extending the benefit under the
IAY.
first and second phase of IAY.
And Lordship, another one is my lord, MSDP.
As well as the second phase of MSDP 2010-11. Full stop. It further appears that by the impugned letter dated 10/6/2014, an attempt was being made to create a new list of beneficiaries by excluding the name of the writ petitioners. What would, however, be significant to note herein that the IAY scheme as well as the MSDP scheme is no longer in force at this stage, and therefore the issue raised in this writ petition has evidently been rendered infructuous at this stage. Full stop. Mr. Das also submits that he is not in contact with his client any longer. Full stop. Be that as it may, the present writ petition was instituted in the year 2014, and at this point of time, the question of preparation of list of beneficiaries for extending benefit either under the IAY scheme or the MSDP scheme 2010-11 would not arise. Full stop. As such, I am of the opinion that there is no live issue that calls for adjudication in this writ petition. The writ petition is accordingly disposed of as infructuous. Interim order passed earlier shall stand vacated.
Oblige, my lord.
Is IA?
I am, my lord.
IA stands disposed of.